Hello, everyone. Welcome to this presentation. Today, we're talking about hearing the voice of the child in family law disputes. Now, in fairness, this is something that is not without controversy. A lot of people, for example, are worried that we shouldn't hear from children because children shouldn't be able to make choices in family law disputes between their parents. Sometimes we worry that children shouldn't become mixed up in their parents' legal dispute or used as pawns in that dispute, that we need to protect children from the conflict between their parents. Another reason is that, well, it's still parents who are responsible for raising their children and for making important choices for them while they can't make them on their own. However, there are a whole bunch of very good reasons why we should hear from children. The research about hearing from children in family law disputes says that generally children want to have their voices heard. Hearing from children can also improve their satisfaction with the outcome of their parents' legal dispute, and it can improve their own satisfaction with their parenting arrangements. And it can increase the chance that their parents will be able to reach a settlement that is fair and that the children perceive to be fair. It also recognizes that children are little human beings all on their own and that they have their own experiences and their own views separate from the views and experiences of their parents. In this webinar today, I'm going to talk about a little bit about the United Nations Convention on the Rights of the Child, because that's the document that frames how we hear from children in legal disputes in Canada. Then we're going to talk about what the Family Law Act in Alberta has to say about hearing from children, as well as what the family law legislation of other provinces have to say. We're going to talk about what the research has to say about how we hear from children. And then we're going to talk about how we hear from children in court and how we hear from children when family law disputes are being resolved out of court. Finally, at the end, we're going to have time for some comments and questions if you happen to have any. And please don't stint. Go ahead and ask. So, at the beginning, human rights. Well, the United Nations Convention on the Child is an international treaty that was adopted by the UN in 1989. It was ratified by Canada 2 years later, and it has the force of law throughout the entire country, including in Alberta. And because it has the status of a law in this country, the terms of the convention are not discretionary, they're obligatory. We've got no choice but to follow these things. The UN Convention describes the basic human rights held by all children, just like the human rights legislation that applies to everybody else. So, and it actually, in fact, gives children a few more rights than adults have. So, for example, children under the UN Convention have the right not to be separated from their parents. They have the right to adequate nutrition and adequate education, in addition to the human rights that everybody else has, such as not to be discriminated against on the basis of gender, sexual orientation, or family status. This is what the UN convention looks like if you look it up on the UN website. And go ahead and read it. There's also a version of the convention which I really like, which is written for children, and that's something that can be extremely helpful for kids. Now, Article 3 at the very beginning of the convention says that in all actions concerning children, including actions taken by courts of law and by governments, the best interests of the child shall be a primary consideration. That's really important because it sort of sets that threshold level of how it is that governments and people like us are supposed to think about children and make decisions on their behalf. But Article 12, from a lawyer's perspective, is the juicy one. This is the one that says that the governments who've signed the treaty, which is every government in the entire world except for the US, will give the child the opportunity to express their views freely in all matters affecting them. And then the next section says, the child shall, in particular, be provided the opportunity to be heard in any judicial proceedings affecting the child, which means court proceedings between their parents. So the convention theoretically only applies to the governments that signed the document. However, we're talking about children's basic human rights, and as a result, it's not just the government that is obliged to honor the basic rights of children, it's also everyday people, including you and me. Now, the convention, in terms of its scope, looking at it from a government point of view, applies clearly to criminal cases. It also applies to family law cases and divorce cases. It also applies in cases of adoption, and in fact, some of the adoption legislation actually gives children the right to express their opinion when they're over a certain age and their adoption is being proposed. Here's a case called BJG versus DLG from the Yukon Supreme Court. This was a decision by Justice Donna Martinson, who's now retired. And Donna used to sit both in the Yukon and in British Columbia. And she was, in this particular case, she was asked to consider whether or not the views of a child should be heard in a battle between the child's parents. And she wrote, "There's no ambiguity in the language used by the convention. The convention is very clear. All children have the legal right to be heard without discrimination. It doesn't make an exception for cases involving high conflict, including cases dealing with family violence, parental alienation, or both. It doesn't give judges or arbitrators the discretion to disregard the legal rights contained in the convention because of the particular circumstances of the case, or the view the decision maker may hold about children's participation in legal proceedings." Now, Donna goes on, and if you read the decision, and I recommend it to everybody, she says that children should, as a result of the convention, be informed at the beginning of a court proceeding of their legal rights to be heard in that court proceeding, that children should be given the opportunity to fully participate early on in the proceeding and throughout the entire court proceeding, including being involved in conferences between judges and the parties, settlement conferences, and potentially also attending court hearings and trials. She says that children should have a say in how they participate so that they do so in a way that works for them. Children have the right to have their views considered in a substantive way, which means that they really have to be not just heard and thrown away, but heard, listened to, and potentially followed, depending on the views of the child and how old the child is. And that children have the right to be informed about the decision that was made by the judge or by the arbitrator, and in the ways in which their views have been taken into account in that decision. Now, this is hard. I mean, and I'm not going to gild the lily here. It's not also not without controversy. The standard that Donna Martinson has set is extremely high, and seems to call for children's full participation from the beginning of a court proceeding all the way through to the very end. And that's hard for judges, it's hard for lawyers, and it's hard for parents. And of course, there's an important difference between appreciating that children have the right to be heard, hearing those views, and then actually acting on what children have said. The reality about our court system is that it's designed for adults, right? And in fact, the primary players in a court proceeding are the adults themselves. Children are never, or well, let me rephrase that. They are rarely ever parties to the proceeding in their own right. And the reality is that children's entitlements under the UN Convention are not supported by the code of conduct that lawyers are required to follow, or they get kicked out of the Law Society. And quite often, we don't think about children as anything other than an element in our clients' cases. In fact, a lawyer's code of conduct only mentions children twice. Once in the context of lawyers' guarantees of loans to their clients, and I don't really understand how children fit into that, but also in the part of the code of conduct that talks about lawyers' duties of advocates. And that section says that lawyers can recommend to their client to take into account the interests of their children, but only if taking into account the interests of children doesn't adversely affect their client's positions. And so that's really problematic because it's discretionary. The lawyer can, or they can choose not to. And they're supposed to not do that if it's going to have a negative impact on their client's cases. So, and then a further struggle in terms of implementing the very high bar set by that case and the UN Convention are that, in general, parents and lawyers, quite understandably, don't want to triangulate the children in the conflict between their parents and put children in a loyalty bind where they can't say one thing without worrying about annoying a parent. We also worry about not using children as proxies to make decisions for their parents. It is a fact that while children have a voice, they do not have a choice, and it's easy to mix up those two, right? Just because a child says that they want a particular parenting arrangement doesn't mean that it's actually in their best interest to have it. We also worry about the extent to which children are involved in the conflict between their parents and the extent to which they're exposed to that conflict. The social science research we have about about parental conflict shows that children can suffer fairly severe short and long-term consequences. In fact, there are only two factors that are the primary indicators of children's adjustment when their parents separated. One is the strength and quality of the children's relationships with each of their parents, and the other is the nature and duration of the conflict between their parents that they're exposed to. And so it's very important in family law disputes to do whatever you can to shield the children from the conflict between you and their other parent. Um, Parents and lawyers, though, also want to promote and encourage children's safety and their well-being, and that's another reason why we're a bit skittish about about overtly involving children in court proceedings the way BLG and BJG suggests we should. We want children to have positive relationships with each of their parents without feeling like they're taking sides. We want children to adapt to the process of the separation of their parents and the restructuring of their family environments in a positive, healthy way. And we also want processes that are child-centered, well-supported, and not just any process, but processes that change depending on the child's age, stage of development, and their maturity. The problem, though, is that from the point of view of court processes and some lawyers, the alternatives to a full-blown custody assessment aren't particularly well known, and I'll talk more about that later. And then the law that applies and the rules of court don't really give us much help in terms of how we hear from kids. The rules of the Alberta Court of Queen's Bench don't really mention hearing from children at all. So let's dive into the legislation just a little bit. First, the rule is that when parents, arbitrators, and judges are making decisions about parenting after separation, the criteria that we are all supposed to consider is supposed to be only about the best interests of children, not the legal interests of parents and their rights and their responsibilities, not the position parents are taking in a particular family law dispute, and not the rights an adult has just because they're the parent of a child. And the laws that we have in Alberta and other provinces, and now federally under the Divorce Act, provide a list of factors that parents, judges, and arbitrators are supposed to take into account when thinking about what the best interests of the child are. They include factors like the nature of the child's relationship between each of their parents, the history of the child's care, the parents' plans for the child's care in the future, and a bunch of other things. Most importantly, though, they also include an obligation to hear what a child has to say. So, under Sections 18 of Alberta's Family Law Act, subsection 1 says that when making decisions about parenting after separation, the court shall take into account only the best interests of a child. And then subsection 2 has a long shopping list of different factors that the court's supposed to consider. And among those factors are all of the child's needs and circumstances, including the child's views and preferences, but only to the extent that it is appropriate to ascertain them. So that's a bit difficult, the only to the extent that it's appropriate bit, and we don't see that in other provinces. So in British Columbia, Section 37 of their Family Law Act says, again, the court must consider the best interests of the child only when making decisions about guardianship, parenting arrangements, or the contact that people who aren't guardians might have with the child. Subsection 2 says exactly what Alberta does. All of the child's needs and circumstances must be considered in deciding the course of action that's in the best interest of the child, including the child's views, unless it would be inappropriate to consider them. And this is important because in Alberta, it's the child's views and preferences, but only to the extent that it's appropriate to ascertain them. But in British Columbia, on the other hand, there's a positive obligation to hear from a child, and it's up to the person that doesn't want to hear from the child to prove that it would be inappropriate to hear from the child. And then if we zip over past the prairies to Ontario, their Children's Law Reform Act at Section 24 says again that decisions about custody and access are supposed to be made considering only the best interests of the child. The court has to, again, consider all of the child's needs and circumstances, including the child's views and preferences, but only if they can be reasonably ascertained. Under the new Divorce Act, which took effect on the 1st of March 2021, Section 16 provides an equally long list of factors that the provinces have always provided about the things that the judge is supposed to consider. Subsection 1, the court shall take into account only the best interests of the child when making decisions about parenting after separation. And then there's this interesting reference to three primary factors. The court shall give primary consideration to the child's physical, emotional, and psychological safety, security, and well-being. And then that long list of factors begins at subsection 3. In determining the best interests of the child, the court shall consider all factors relating to the circumstances of the child, including the child's views and preferences, giving due weight to the child's age and maturity unless they cannot be ascertained. So just like in British Columbia, but not like in Alberta, the Divorce Act contains an assumption that you will hear from children, and it's up to the person who doesn't want to hear from a child to show that they cannot be reasonably ascertained. So there's good news though. For parents, the benefit of hearing from children is that quite often hearing from somebody else what the children actually think about what's going on can improve their chances of settling a family law case. It's often sometimes the only way that they're going to hear what the children actually think. And the reality is that children are incredibly smart. They know what side their bread is buttered on. And so as a result, if a child knows that mom doesn't want to particularly hear anything good about dad, the child's more likely to say things that are going to satisfy mom, exaggerate the disadvantages of being with dad and emphasizing the criticisms the mom has. So for example, let's say there's a child who really loves pizza night at dad's house. Child goes to dad's house. Dad says, "Hey, let's make pizza tonight." The kid's, "Great, that's fantastic. I love your pizza." But when the child goes to mom's house, knowing full well that mom doesn't particularly want to hear lots of good things about what happened at dad's place, the child will often say, in response to the question, "What did you have for dinner last night?" The child will say, "Oh, we had pizza. It was awful." Things like that. And that's not and so what happens is that in the point of view of a family law case, dad will write an affidavit, for example, or give evidence on the stand saying, "Oh, we have a great time. The kid loves my pizza. We enjoy doing it together." But then mom's evidence is exactly the opposite. Mom will say, "Well, the child tells me the child hates pizza night at dad's house." Or to give you a different example, one of the other things that I do is I also work as a parenting coordinator, which is a kind of a hybrid of mediation and arbitration, where I try to help parents implement an order, an agreement, or an award about parenting arrangements after separation. I had one file where the parents were delighted to spend thousands of dollars arguing about whether the child wanted to play soccer or baseball during the summer. And the thing was, from mom's point of view, she was saying, "Well, do you want to play soccer or or baseball?" And the child was saying, knowing that mom is a particular fan of soccer, "Oh, soccer, I want to play soccer." But going to dad's house, where dad's the fan of baseball, "What do you want to do this summer?" "I want to play baseball." And really, the child actually thought something else altogether. It was up to me to talk to the child and say, "Well, what do you want to do this summer?" And sure enough, the child picks soccer. And the point there is that, again, children are smart. They know what side their bread is buttered on. So the child is telling mom what mom wants to hear, telling dad what dad wants to hear. It doesn't mean that the child is lying or the child is misbehaving or being disingenuous or anything like that. It's just a natural self-preserving kind of thing. But the benefit from hearing from children from an independent source is that this is sometimes the only way parents really hear what the child actually wants. The other benefit is that sometimes after hearing from a child, the outcomes are better and the parenting arrangements are arrangements that children are much more likely to be happy with. And then from children's point of view, there's benefits there too. Hearing from children recognizes that, well, they're independent, autonomous individuals who have their own experiences, feelings, and perspectives that are different from what mom might have to say or what dad might have to say. It acknowledges that children are truly independent, have human rights of their own, and an opinion of their own. And the social science research we have, and I'll talk about this in a second, says that, well, hearing from children actually improves their overall experience of the process of their parents separating and the family restructuring into a different format after separation. And sometimes it can improve the longer term outcomes for children. Getting back to parents, hearing from children can improve. Oh, I think I pressed the wrong button. Yeah, there we did. This is the part about the research I was mentioning. So here's and I guess the curious thing is that social scientists, psychologists, and social workers and academics actually spend a lot of time thinking about the process of family breakdown and family restructuring. And there's a whole ton of literature that's all about the research that's been conducted about how to improve outcomes for children, parents' perceptions of justice processes, and things like that. And among other things, we also have a fair amount of research about the effects on parents and on children from hearing the views of children after parents have separated. Two of my favorite pieces of research are the works by Rachel Birnbaum and Michael Saini that are referenced in the bottom two bullet points on that slide. A scoping review of qualitative studies about children experiencing parenting after separation. Don't be put off by all the academic talk. It's actually a very easy to read paper and it's extremely valuable. And the other one, a qualitative synthesis of children's participation in custody disputes. And again, don't be put off by the academic language. What was important about these two bits of research is that Michael and Rachel surveyed hundreds of studies about hearing from children after separation from all across the globe, and they synthesized the results of all those different studies into these two papers. And I'll tell you that when I first read this, it was incredible. It opened my eyes to how children really do experience issues about parental separation and the value to children of having their voices heard. So, what Rachel and Michael found is that children, in fact, want to be involved in the processes that develop the parenting plans that they're going to be subject to after their parents separate. They want to be consulted about making decisions about parenting after separation, and they want to know what the outcome was, what the agreement between the parents was, what the order of the judge or the arbitrator was. Children also, they don't want to have to choose, and that's important because we shouldn't be offloading important decisions that are really adult decisions onto children. They don't want to be put in that position of responsibility of saying, well, these are the parenting arrangements I want, but they do want to provide input. And children prefer to be involved early on, including when parents make the decision to separate. And children also want to be treated with respect, acknowledged, and listened to. They also found that, this is not all a bed of roses, of course. When parents separate, children experience profound feelings of vulnerability. After all, for most kids, what's coming to an end is the stable family unit that they have known ever since they were born. And it raises a lot of questions for kids that if this is going to change, what else in my life could possibly change? And so they experience fairly deep feelings of loss and regret, and they have anxiety about the future, and they're anxious about being asked to choose, which is why it's so very important not to ask them to choose. When we ask children what their views and preferences are, we're not saying, I want you to make a decision about when you're going to see dad number one and dad number two. We're asking you to tell me how you're experiencing all of this, and if you had, and how do you, what kind of parenting arrangements might possibly work best for you, or if you have existing parenting arrangements, how could they be improved, changed? And Michael and Rachel also found, this is very interesting, that children actually want fair results. And this is that bit about it improves children's perceptions of outcome. Because if children think that the result was fair from their perspective, they're actually much more likely to be happy with it. So let's move on and talk about how we hear from children. And first, we're going to talk about how we hear from children in court. So again, I keep pressing the wrong button. My apologies. So most of the time, most often, judges and arbitrators hear about children's views and preferences from their parents. Mom or dad will give evidence on the stand or in writing in the form of affidavits about what their kids have told them and what they think is in the children's best interests. So this is normal. The problem, though, is that what parent number one says is often at odds with what parent number two has to say. On the other hand, hearing children's views and preferences from the voice of their parents is cheap. You don't need to make any special arrangements for the judge or a psychologist or an arbitrator or a lawyer to interview the children. And technically speaking, this at least complies with the obligation under Alberta's Family Law Act to hear children's views and preferences, and the obligations the judge is under to make sure that their views are heard and considered under the United Nations Convention on the Rights of the Child. On the downside, though, parents' memories are often and quite reasonably affected by their legal positions. And that's just human nature. If you have this particular goal, your memories wind up being shaped as you think about things in a way that tends to favor that ultimate goal that you're looking for. If you've ever played that game of telephone when you were a child, where one person tells the other person a short story, that person tells somebody else, and by the time it goes back around to the beginning of the circle, the story is often entirely different than how it started. And that's often what happens when parents are repeating to the court what their children have told them. They may not be getting it exactly right. And of course, all of this information is really easy to manipulate by a parent to suit their own legal goals. And then there's that last point, which was about, baseball versus soccer, or whether or not pizza night at dad's house is any good. Kids don't always tell their parents the same thing. We also get Dear Judge letters from time to time, and these are peculiar things that I don't see all that often, and I'm always surprised when I get them. The child will write a letter to the court saying, Dear Judge, this is what I want to happen. And of course, on the positive side, well, it's cheap and fast. You don't have to do anything special to make it happen. Again, it's a way of complying with the convention as well as the Family Law Act. But it's not always clear what it is that motivated the child to write the letter in the first place, or whether a child was coached or prompted to say particular things. Now, when you write to the judge, you make sure that you tell the judge how much you don't like pizza night at dad's place and things like that. And videos are often even worse than Dear Judge letters because the videos I've seen generally consist of a parent videotaping the child, usually on their phone, right? And the parents are asking the children questions that are most of the time designed to produce a particular outcome, such as saying, You don't really like spending all that much time with your mom, do you? That's a question that contains the answer in it. Like instead of saying, how much time do you like spending with your mom? Or how do you like the time that you spend with your mom? It's suggesting that maybe there's a problem with the amount of time the child has with the mom and is encouraging the child to say, no, I don't want that much time. So they're very difficult and they're very problematic. And as an arbitrator myself, I tend not to give much weight to that kind of a video because if the child is being prompted and coached and asked questions that suggest their own answers, it's not very helpful to me in trying to decide what the child actually thinks about things. Sometimes we also hear what children have to say from adults who are not parents. This is better, certainly, than hearing from parents. And typically, this will come in the form of an affidavit or evidence from an aunt or an uncle or a neighbor, teachers and coaches and psychologists and counselors and social workers and people like that about things that the child has said to them. So again, this is cheap and it's fast, although, if the evidence is being presented in an affidavit format, somebody has to pay for the affidavit to be drafted and then executed. It also complies with the Convention of the Family Law Act, but there are some downsides. Among other things, well, the reality is that family members and friends tend to be partisan. They favor one parent over the other. And so you're not getting a completely neutral statement. You're getting the statement from somebody who is predisposed to favor one parent more than the other parent. And then, of course, there's also no guarantee that the child hasn't prompted, that the other adult hasn't prompted the child to give the answers that they're looking for. But there are other alternatives, and one alternative, which is surprisingly commonly used in Alberta, is appointing a lawyer to act for the child. This sometimes happens when it's clear that neither parent is going to be able to distinguish the child's best interests from their own personal legal interests. The good side of appointing a lawyer for a child is that the lawyer will know the law. They'll understand the best interest factors. They usually have special training in dealing with children and in representing children. And so, in general, they're going to do a very good job. The other thing is that the lawyer will, generally speaking, not just be a mouthpiece repeating the things that the child has said to the court and to the child's parents, but also advocate, make arguments in favor of the outcome the child wants. On the downside, this is expensive. Children's lawyers aren't covered by legal aid. Children's lawyers are also not especially helpful in cases of alienation and estrangement. And those cases are cases where a child has become aligned with one parent against the other parent. These are always very difficult cases. And sometimes you hear about it in terms of a child being poisoned against another parent. And if the child has formed, for whatever reason, a real dislike towards one parent, appointing a lawyer for them isn't necessarily going to improve the overall family situation. It's not going to do anything to encourage the child to reconcile with the parent that they've decided that they don't like. Instead, it will tend to entrench and deepen the child's resentment of that parent, because now they have a lawyer who on their behalf will say, well, the other parent is not a competent parent. They do things the child doesn't like. The child doesn't enjoy spending that much time with them. The child, in fact, wouldn't want to see that parent at all. So it's not really promoting the overall needs of the separated family, or really the benefits of reconciliation towards the child. And then we have things called parenting assessments. In Alberta, you frequently hear them referred to as bilateral assessments. In other provinces, they may be called a parenting arrangement assessment or a custody and access report, things like that. These are clinical reports that are prepared by a qualified social worker, psychologist, or psychiatrist who interviews the child, spends time with the child with each of the parents, and then usually administers a bunch of different tests to each parent about their parenting skills, the extent to which family violence is a factor, and a few other things. So the good news about reports like this is that it's not just about what the child thinks and their views and their preferences, but the assessor will usually provide a much broader report that talks about things like each person's parenting skills, about the adequacy and sufficiency of the environment that they're providing to the child in their separate homes, and their strengths and weaknesses as a parent. So that's very helpful. And this kind of report is really the only kind of report that's capable of getting to the bottom of cases involving alienation or estrangement. Again, that's a case where a child has developed a dislike for one parent and is aligned with the other. The downside, though, is that particularly in Alberta, these reports are very expensive. The typical cost is between $20,000 and $40,000, and they typically take about 6 months or longer to complete. Now that's different than in next door over the Rockies in British Columbia, where these reports are still expensive, but they tend to start at around $6,000 and maybe go up as high as about $15,000. And they tend to be completed in between 3 and 6 months rather than 6 months or longer. And so these reports are very expensive, but when a judge or an arbitrator is dealing with a situation where they can't make heads or tails of the evidence, where each parent is presenting a compelling case, but their visions of the future are completely at odds with each other, a parenting assessment is gold. It gives us the insight that we need to have to really understand the family dynamics, the views and preferences of the child, and make a good decision about the parenting arrangements that are most likely to be in the best interests of the child. However, bearing in mind how long these things take to complete and how long, particularly in Alberta, it takes to get to a trial, you may find yourself in a situation where you've spent $20,000 or more on that parenting assessment, but because of delays getting to trial, you may have to get an update at, of course, further cost. Then there's also the option of obtaining something called a Views of the Child report. This can be a report by a mental health professional that's done in the same way as a parenting assessment is done, but it's much more compressed, where the mental health professional isn't spending time administering all sorts of psychological tests to the parents, doesn't spend time seeing the child interact with each parent. And really, the job of the mental health professional is really to speak to the child. But when it's a mental health professional and they're assessing the views of the child, they're providing an opinion about what the child has had to say. The opinion might cover things like the strength and consistency of what the child has had to say. It might touch on the likelihood that what the child is saying and that they prefer is actually in their best interests, or that the preferences the child has expressed are the child's actual preferences. And so this is good. It's good to have that opinion from a mental health professional. But of course, because we're talking about an assessment, well, it isn't just about interviewing the child and spitting out a report. You get something longer, which actually contains the mental health professional's opinion about what they've heard from the child. And that can, of course, cost more money and take more time. Not nearly as much time or money as a parenting assessment costs, but it's still expensive and it still takes some time. On the other hand, there are non-evaluative reports. Those are reports that could be prepared by mental health professionals, but they could be prepared by anybody else who has experience and training interviewing children. For example, I'm a lawyer, and I've been doing non-evaluative views of the child reports since like 2007 or something like that. Those reports are different. There's no opinion, there's no assessment. The person merely meets with the child and reports back to the court, to the mediator, to the arbitrator, to the parents, what the child has had to say. The benefits of these kind of reports is that they're cheap and fast, whether we're talking about an evaluative report or a non-evaluative report. Non-evaluative reports, because there isn't that extra stage of preparing opinions, are especially fast. I've sometimes been called by a judge at the morning recess and asked to prepare a views of the child report in time for the resumption of court after the lunch break. And you can do these sorts of things. They're really fast. And because they're fast, they also tend to be inexpensive, or at least not nearly as expensive as other kind of reports. If you can't afford but need a full-blown bilateral assessment parenting report, this is a reasonable, not entirely the same thing, but it's a reasonable alternative to getting that much more expensive report. On the other hand, they're not always great for younger kids. My personal threshold is right around age 6. A mental health professional who's preparing an assessment might be comfortable interviewing children younger than that age. But for me, age 6 and up, I'm good to go. I'm golden. I don't need any particular help, and everything is just fine. The other thing that they're not good with is those cases involving alienation and estrangement, where a child has developed an antipathy towards one parent and an alignment towards the other parent. If you ask the child, what are your views and preferences? They're going to tell you exactly that. So you wind up with a views of the child report, whether it's evaluative or non-evaluative, that just simply repeats the child's negative views of the parent that they have decided that they don't like. And remember that the non-evaluative reports do not contain any assessment from the person who's speaking to the child. For example, I cannot and will not offer an opinion about whether the child's behavior demonstrates the presence of alienation or estrangement, whether what the child has said to me demonstrates coaching by a parent or diligent prep work done by the parent to ensure the child says certain things to me. I can't do that because I'm not a mental health professional and I don't have the skill or the experience or the education to provide an assessment. Then sometimes you actually have cases where the judge or the arbitrator will actually meet with the child. So this is great because it's free. Nobody's paying anything for this. And it's fast because a judge will usually speak to a child in their office in the courtroom, which is awesome, right? It's certainly a reasonable alternative when a parenting assessment costs too much and takes too long, or when a views of the child report isn't available. But again, just like a views of the child report prepared by somebody who isn't a mental health professional, judges and arbitrators may not be comfortable interviewing younger children. And in fact, I know lawyers who do views of the child reports who aren't comfortable dealing with kids younger than age 8. And it's going to depend hugely on the views and the preferences of the judge or arbitrator who's dealing with the case, because they have to make the decision to speak to the child. It's not up to you, it's up to them. Um, the other thing, though, is that from the point of view of judges in particular, judges are very concerned with procedural fairness and making sure that how they have dealt with a trial is beyond reproach and won't find themselves getting appealed to a higher level of court. And so as a result, judges typically have lots of questions when they're being asked to interview a child. Will anybody else be in the room with me? Should I have a court reporter take notes about what the child has said? Do I need to make an audio-visual recording of what's happened? Does my interview and the notes I take, does it form part of the record that will go to the court on appeal? And there are a whole bunch of other concerns that judges have, more so than arbitrators will, but concerns that judges have about the integrity of the overall process and how their interview, which is usually not subject to a cross-examination, usually not conducted in the presence of the lawyers for the parents, how their interview is going to be treated in the event they get appealed. So judges are going to be skittish about this, but if you have no other way about getting an independent person to hear from kids, there's no harm in asking a judge if they'll speak to the kids. Some judges are delighted to do that. Others, of course, are not. Now, when we're out of court, and we're reaching the end of my prepared presentation, you'll be glad to know, but when we're dealing with things out of court, there's a whole range of options. Collaborative negotiation is like is negotiation on steroids. When people try collaborative negotiation to resolve a family law dispute, they each hire a specially trained lawyer and they sign agreements that require them to be fully transparent about the information they have and require them to cooperate. And the two lawyers and the two parties work as a team to try to resolve a dispute. The interesting thing about the collaborative process is not just the highly cooperative nature of it, which sort of runs against the grain for a lot of lawyers, to be frank. It's how other people can become involved in the process when you have a particular need. So, for example, if you have a complicated tax problem or a complicated problem about property division or spousal support, you might bring in a financial expert who can come and give advice to everybody about the best way to restructure a family company or the best way to deal with property while minimizing tax consequences. Well, that's awesome. One of the experts that you can involve in the process is a child specialist. And this is an independent person, always a mental health professional, who the parties and their lawyers ask to come and be involved in the process, specifically for the purpose of giving recommendations about what the best parenting arrangements might be. And among other things, they can also speak to the children and represent their interests when speaking to mom and dad and their lawyers. Um, in the collaborative process, you're not locked into child specialists only. You can have anything else you want, which might include the non-evaluative reports that I and others prepare. It could be the evaluative views of the child report that mental health professionals can prepare. It could be that bilateral assessment or the parenting assessment. That's that very long and very expensive report. Or you could even have the children come and attend different sessions or parts of sessions to be there present when the lawyers and their parents are talking about how parenting arrangements might be sorted out. Mediation is a different kind of process. In mediation, the people involved in the dispute hire a neutral third party, a mediator, to help them talk to each other, help them identify their underlying interests, and help spot opportunities for compromise. The job of the mediator is not to make a decision. They just don't have that power. The power to make a decision, the power to settle a case is always in the hands of the parents. The job of the mediator is to help them talk to each other, to smooth things over, to engage in dialogue, to probe for potential solutions, and then to talk about these things with the parents. So normally, mediation either happens between the mediator and the two parents, but it also happens quite frequently with the mediator, the two parents, and the parents' lawyers. There's nothing stopping the mediator from deciding, well, you know what, I want to go interview the child. The mediator won't do that unless everybody agrees, or at least unless the parents agree, but that's certainly an option. And usually what happens is the mediator will meet with the child privately and then report back to the parents and their lawyers about what the child has to say. But you could also hire the same kind of child specialist that you used in the collaborative negotiation process, and you can still have evaluative and non-evaluative views of the child reports. And if you've got deep pockets and time to spare, you could also have that full-blown parenting assessment if you want. And then finally, arbitration is a kind of private court. The difference between arbitration and litigation is that you can force somebody to go to court, but you can't force somebody to go to arbitration. They have to agree to do it. And in arbitration, you still have a neutral third party who's making a decision. In litigation, that person is the judge, and in arbitration, that person is an arbitrator. However, unlike going to court, where your judge is the person drawn almost randomly by the trial coordinator, you get to pick the arbitrator who's going to hear your case. So, for example, you could hire a lawyer who's not just a family law lawyer and known for their expertise in that, but a family law lawyer who has specific expertise in the particular issues that you're dealing with, which might be complicated tax issues or property issues, or might be making decisions about parenting after separation. So in cases like that, just like asking the judge to interview the child, you can ask the arbitrator to interview the child. Arbitrators are going to be slightly more willing to do this than judges are because arbitrators are not quite as caught up as judges are in the formalities of the litigation process and in fears about getting appealed. Other alternatives include evaluative and non-evaluative views of the child reports. Again, those expensive parenting assessments. The arbitrator may also recommend to people that maybe this is a good dispute in which a lawyer for a child is appropriate, right? And the lawyer will be the person who's able to spot whether or not retaining a lawyer to act on behalf of a child is going to add anything to the process or just delay things and increase costs. And then there are other ways you can hear the views of the child in terms of a social worker, for example, who's there to, represent the children's needs and they express what the children have said to them and things of that nature. And just like in litigation, you can sometimes have dear arbitrator letters and videos, but for me, those are an absolute last resort because they suffer from the same problems as dear judge letters and dear judge videos. You don't know the backstory behind why a letter was written, what was motivating the child to write the letter, and whether or not a parent, for example, coached the child about what to put in that letter. And the videos are just as horrible in arbitration as they are in litigation. So at the end of the day, I think the thing to take away from this is that in Alberta and in the rest of Canada, people who are involved in a family law dispute have a positive obligation to try to hear what children think, their views and their preferences about their experience and about the family law dispute. There are a whole different wide range of ways that this can be done. And even though parents, lawyers, and judges often have a completely understandable reluctance to hear what children have to say for fear of involving them in the process, for fear of exposing them to their parents' conflict, the research we have available, in particular those two papers from Rachel Birnbaum and Michael Saini, give us a whole wealth of information about children's actual experiences. And the important takeaways from their research are that children want to be heard from. They want to be heard from early in the process, even at the time of separation. That hearing from children increases their satisfaction with the outcomes in terms of their parenting arrangements, and hearing from children increases their perception that the result of the dispute between their parents is fair and equitable. So, Those are the comments that I have prepared. I would be delighted to take any questions or comments that anybody might have to say. Please open the chat box and type in your questions, and as they come in, I will be happy to answer them. To everybody who attended. And I'd like to say thank you very much to the excellent folks at Alberta Health Services Community Education Service. If you don't know about the services that Community Education Service provides, go to their website. They have a phenomenal list of talks provided by pediatricians, doctors, psychologists, experts on addiction and substance abuse issues that are absolutely fantastic. And it's an amazing parenting resource that I just simply cannot recommend highly enough. So please go to their website, look at what else is coming up, check out their video library. This is one of those things where government got it right in terms of allocating their funding. So thanks very much to everybody, and thanks very much to the nice folks at Alberta Health Services. Thank you.